Good morning, everyone. This is Robert Wieber, and I'm going to present to you today my predictive research presentation on the state jurisdiction of Tennessee. So my initial thought analysis of the facts with Jason and Mark were that this is a civil lawsuit for damages. So technically, we do not know if a criminal complaint was adjudicated on the facts. So I moved forward with that in mind. From our facts, we know that Jason was the aggressor. Mark refused a request by Jason to punch him. Jason grabs Mark's arm. Mark's reaction is to punch Jason in the head or facial area, causing him damage. But does Mark have Jason's consent to punch him? This was really the key legal question that I felt needed to be answered before looking into defense or any other options or questions really with this case, to be honest with you. So as you can see, I kind of pre-set up my Westlaw website only because the program that I use when I type or use a mouse, it actually does something with audio, nobody can hear me talk. So if you'd be a little bit patient with me, I really appreciate it. I'm going to try and go through this as quickly as possible within the time constraint that we're allowed for this presentation. So to begin with, I start off in Tennessee, and I did put the Sixth Circuit for federal cases. I'm going to focus mostly on state cases. That's what I was looking for with all my searches. So let me go. Okay, so basically the first search actually brought up 139 cases, which I know it sounds like a lot. I didn't actually go through all of them. I think with a little bit more facts pertaining to the case, I may have been able to narrow it down, and it may just come to me over time with experience that I'll be able to do better search connectors in the future. But anyway, to begin with, during all my initial searches, the second case here that we see is Klein by Klein v. Jordan, and that came up in a lot of my searches. So let me go ahead and bring up that case. Okay, so Klein by Klein v. Jordan is the citation for that is 685, the Southwestern Reporter, second edition. It begins on page 295, and it was decided by the Court of Appeals of Tennessee, Western Section of Jackson. And basically this case involves a minor child and his father who brought a suit of assault and battery against the director Robert Jordan of the University of Tennessee Child Development Center when his Klein's son was injured by a staff member. Essentially, from what I remember from the case, he basically had an injury to his lip, which the director checked, and I don't recall, it didn't say specifically if there was any first aid rendered to the child. But specifically, this case revolved around whether the director had consent to actually touch his child. And I'd like to go ahead and scroll down and show you that consent section, because I believe that really applies to Jason and Mark's case. So in Klein v. Klein, or Klein by Klein v. Jordan, for a cause of action for assault and battery to arise, there must be an absence of consent. They actually cited Ray v. Schreiber, which is 484 Southwest, second edition, begins on page 63. That was decided by the Tennessee Criminal Court of Appeals in 1972. And looking at this case, it specifically says consent may appear from the circumstances so that if there was some manifestation of consent upon which the defendant, Mark in our case, could reasonably rely, he would not be liable for Jason's damages. As W. Prosser states in the Law of Torts, Section 18, 4th edition, 1971, consent to an act is simply a willingness that it occur. And we see that in our particular case, Jason definitively gave Mark consent to hit him. And that he had a willingness that that act should occur. So it goes on to say that actual willingness established by competent evidence will prevent liability. And we know from our facts that Jason grabbed Mark's arm, pulled it towards his stomach, in an act to show Mark that, hey, I want you to hit me, and said, come on, man, I can take it. So this, to me, is competent evidence that Jason wanted Mark to hit him. And I like this part of the case. It says specifically, in our society, we must perforce, I'm not sure if I'm saying that word correctly, perforce rely upon the overt words and acts of others rather than upon their undisclosed minds, which means Mark couldn't read Jason's mind. He told him, this is what I want you to do. He grabbed his arm, showed him, and even though Mark reacted differently than what Jason did, essentially he had consent to hit Jason, is what I would argue with this particular case. And it says that consent therefore be manifested by words. The defendant, Mark, is entitled to rely upon what any reasonable man would understand from the plaintiff's, Jason's, conduct. I really like this case. I think it fits the parameters of what consent for Mark to have actually hit Jason, and therefore he wouldn't be liable for the damages to Jason because he had consent. And there was another question that I really thought needed to be answered that was brought up, and that was to address what level of intoxication is basically a bar to giving verbal consent. And looking at a number of cases online in Tennessee, the law does not make a distinction that would have, I think, a bearing on this case. Both Jason and Mark were able to talk and were conscious. We just do not have enough information to make a clear analysis of this particular fact in this case. I don't think a defense option is really necessary because it says for a cause of action for assault and battery to arise, there must be an absence of consent, which clearly I think Mark had from Jason. And so I really feel that with the judge affirming the decision that the defendant had consent to touch or that he wasn't liable for assault and battery against Mr. Klein's son, I would have to say yes, the court would likely grant the motion to dismiss Jason's claim, to dismiss. Jason's claim, I think, would be tossed out, and a Mark avoids liability in this particular case within Tennessee. So that's my presentation. I hope everybody enjoyed it. I hope I made some sense. I'm going to go ahead and post this up for everybody. All right. Thank you for listening. Take care.